Welcome to EB5 Investment Voice, where attorney insights intersects with immigration investments. If you are a foreign investor, domestic fund manager, or enterprising entrepreneur and want to get the most out of the EB5 program, you have come to the right place. I'm Mark Deal, and I'll be your co-host on this journey. I'm joined by your host, Mona Shaw, and other attorneys at Mona Shaw & Associates, as well as immigration leaders from around the world. So let's get into EB5 Investment Voice.
Hi, Mark.
Hey, Mona.
This has really been a week for news from USCIS. I mean, we just had all of that redeployment issue, which, of course, we've already been discussing, and we will discuss more. But yesterday, yesterday being July 29th, there was a hearing in front of the Judiciary Committee. It was a subcommittee, actually, on immigration and citizenship with regards to oversight of USCIS, as USCIS are going through all kinds of troubles right now. And good for us, but IIUSA had put together a report with statistics, which really, I don't want to give too much away because it's quite exciting. And we have with us today Dan Lundy from Klasko's office, who was one of the contributors of this report. So we thought this was very timely to discuss this.
That's right, Mona. Not only was Daniel B. Lundy a major contributor to this report that we're about to explore, but he's also an EB5 attorney with a wealth of experience. Dan represents numerous EB5 developers and regional centers and works with accomplished network of security lawyers, economists, business plan writers, and other professionals, such as Mona, to structure development deals that are EB5 compliant. He has also helped to preserve the immigration interests of investors and has extensive experience litigating cases for clients challenging adverse actions by USCIS. And we'll probably hear a little bit more of his tool of choice later on in this episode. Dan, welcome to the show.
Thanks, Mark. Hi, Mona.
Great to have you, Dan. So you are one of the contributors for this wonderful report that I'm actually looking at right now. It's an excellent analysis and quite a quantitative review of USCIS's revenue collection from filing fees.
Yeah, so I noticed when I was looking at the USCIS All Forms data, which they publish generally quarterly, usually a quarter in arrears. So we're only up to the second quarter 2020. We only have up to March 31st. But the data up to March 31st, 2020 shows that in fiscal year 2018, 2019, and the first half of fiscal year 2020, there has in fact been no slowdown at USCIS. Overall case receipts are actually up year over year, and adjudications are significantly up, which corresponds, of course, to an increase in filing fees. Now, we haven't been able to figure out exactly at what point USCIS gets to claim filing fees, but we've heard that it's tied to adjudication. I don't know if it's the start of adjudication, the end of adjudication. So between filing and adjudication, if adjudications are up, it means they should be drawing down more money. At the same time, they're claiming that they're bankrupt and going to have to lay off 13,000 people. Now, granted, we don't have the data from March 31st on where they claim that receipts were down 50% from COVID. But honestly, we just don't believe it.
Yeah.
And in fact, showing that they don't, in fact, have a deficit. It looks like they're going to end fiscal year 2020 with a surplus. And now they're claiming they need money, fiscal year ends September 30. And now they're claiming they need money from October to December, or they're going to have to furlough people.
Yeah, I mean, even if you just take the end of last year when we had that deadline and there were so many more applications, and each application, especially for EB5, is so high.
Yeah, and the filing fees for EB5 are extremely high. Unfortunately, adjudications are extremely slow because, for every 924 with a $17,795 filing fee that they adjudicate, they take down a rather significant amount of money. And we know from their notice of proposed rulemaking on the fee increase that they don't actually use all EB5 fees for EB5 adjudications.
No. And if you actually look at the data that you actually put in, the employment pace is significantly more than many of the other categories.
Yeah, and the other issue we had, or I shouldn't say we, I had the idea and mentioned it to IAUSA, and the people there who are smarter than I am actually crunched the numbers. But one of the issues was that one very big revenue source for USCIS is premium processing fees. And there was no Form I-907 listed in the data. So we weren't able to calculate how much money they made from premium processing. So our numbers are actually low. We were able to parse out I-131s and 765s that are filed with an adjustment, because those are not feed in. You don't have to pay a fee for those.
Right.
But we were able to pull those out of the data to make sure we didn't overcount them. Yeah, bottom line is we underestimated the filing fee revenue, but the picture emerges. So one, USCIS cut off premium processing for most of the year and only recently reinstated it. Well, when they do that, they cut off a revenue source, a rather significant revenue source. If you look at some of the documents they put out before the hearing, they literally collect close to $1 billion in premium processing fees in a given year.
Right. And according to this as well, for the EB5 side, because those are the figures that we do have, as of March 2020, there was a total of 5,502, 726 cases, which represents approximately 2.94 billion in filing fees.
Wow, I'm surprised that backlog is down to that. I thought the backlog was still around 15,000. I know there haven't been a lot filed recently, so maybe that's it.
That's what threw you off. It was the number that was almost 3 billion. That's what piqued my interest. It's a lot of fees.
There's a lot of fees there. So this was great.
So forgive me for jumping in. I just want to paraphrase this and kind of put it into language that I understand, not as an immigration attorney, but as a reformed data scientist and Woodful CPA. But it sounds like the number of filings have remained the same. So demand is pretty much constant, but the adjudication times have been getting longer. So the fulfillment process is getting slower. And it sounds like there's no line of sight to these premium processing fees. They're not using some type of activity-based accounting. They really know where the dollars are going and to where. And because of that, it sounds like maybe there is, I wouldn't say fraud, but maybe there is some waste on the immigration side. Is that what the report was somewhat highlighting?
Well, the report doesn't actually go into the waste. We can certainly talk about the waste and why.
Oh, we don't have to. I'm just wondering if that's what it was.
Well, no. What the report does is analyze the claim. And again, unfortunately, it only goes through March 31st, 2020. What it shows is that receipts year over year are up. I forget if it's 5 or 9%, and adjudications are up about 15%. So if you get your money when the case is receipted, that means that they're making more money than they made last year. If you're making your money when you adjudicate, it means they're getting a lot more money than last year.
I see.
But they're claiming that revenue is down 50%.
Okay, no, that makes sense. Actually, you corrected me because I was thinking it was the time to adjudicate, but it sounds like they're actually adjudicating more, but not enough to offset the increase in the filing fees.
Well, oddly, the time hasn't decreased at all.
Oh, okay.
Yeah.
All right. Well, thanks for that clarification, Dan. And I'm glad we have you to kind of set us straight here.
It's so interesting, Dan. And isn't it fun to put USCIS back on the spotlight rather than the way they are hammering us right now?
Oh, yeah, there needs to be a spotlight.
So, Dan, we do have to speak about the topic of the day, which is redeployment. But before then, as I have you here, and as I know you're so good in all of the RC Regional Center due diligence and all of those things, I did want to ask you a couple of questions on that front.
Sure.
You've been doing this for some time, though, right? The due diligence of regional centers, et cetera?
I've been representing regional centers since about 2012 now. And yeah, we were the first people to develop a regional center compliance program to try to help regional centers make sure they have what they need for audits and for 829s and investor filings.
But it was easy back in 2012, and it's not now. Oh my God, this last form from last year, how the 924, the changes on that certainly threw us because we didn't expect all those changes.
Yeah, change has been a constant. The changes lately are not as fun and interesting as the previous changes.
Well, there's a lot more depth. But let me ask you, how much due diligence responsibility does a regional center really have to do with regards to its investors? Because I'm asking you this as we have started seeing NOIDs and issues coming from USCIS, RFEs and NOIDs saying to regional centers, you have not put enough due diligence responsibility into this, or you haven't done what you're supposed to do.
The interesting thing is the regulation, neither the regulations nor the statute actually state what the standard is that a regional center needs to adhere to. The regulations say the regional center needs to submit a plan, which includes a plan of how it's going to operate, how it's going to conduct oversight of the investments, and how it's going to conduct due diligence on the investors. But there's absolutely no standard anywhere in the law about what that plan has to be. So there has to be a plan, but there's no way to judge the plan. So to the extent that USCIS is asking about this, there's no law, and they're making it up as they go. Not even the policy manual really spells out what a regional center's duties are. And of course, when they fill it in as a matter of their discretion, it's a problem for everybody because there's no consistency, there's no standard, and there's a lack of due process. So yeah, honestly, I hope those people take them to court. It's been my pastime lately is suing USCIS.
Yeah, I'm coming to that too. I do agree, but at the same time, I think we have a view that there are people out there who have regional centers who, quite frankly, Dan, should not have regional centers. They really don't know what they're doing, and they have no idea how to have any kind of responsibility, what kind of responsibility is required, even at the basic level for their investors. And there is a lot of conflict of interest when a project is the regional center and that same project is the issuer, and it's also their project which is receiving the money.
Yeah. So part of the question is, what diligence does a regional center have to do? Kind of has to ask the question of what is the actual relationship between the regional center and the investor? Because, sometimes the regional center is the manager of the new commercial enterprise. Sometimes it's not. Sometimes it's the borrower and the lender and the developer. Sometimes it's not. Sometimes there's absolutely no privity between the regional center and the investor. But I guess we can kind of use regional center and new commercial enterprise interchangeably here. I mean, you certainly have some obligation to vet your investors, but my feeling has always been if the banks take the money, there's a pretty good chance that your client is not a terrorist or a drug dealer because they've already passed the OFAC test.
Yeah.
And they've already passed Know Your Customer and anti-money laundering requirements at the bank. And if that's good enough for the Treasury Department, it should be good enough for USCIS.
Oh, I agree wholeheartedly. And this is one of the reasons why I always encourage escrow accounts, because I feel that is one layer which has been taken off you. So true, I agree. There is no standard. There should be, quite frankly, I think there should be more rules and regulations for regional centers. But now we are starting to see a lot of NOIDs. I know, Mark, you're going to tell me what's a NOID again, not to use.
Notice of intent to deny?
No, to NOID, T.
Oh, NOID.
Notice of intent to terminate, and that's the issue to a regional center. So this year it's been a fun year. There were a bazillion amount of NOIDs which were issued. Some for people who hadn't filed their compliance documents, and some who had filed the compliance documents, but USCIS perceived there to be a lack of economic activity. So how would you deal with a situation like that, Dan?
So I sense that the rules may be changing again because previously they just didn't care. They were happy to take the 924 and the A and the $3,000 filing fee every year, which, by the way, helps with their budget problems.
Yeah.
So, why would they want to continue taking the money for a 5-minute adjudication? So they used to be after 3 years of inactivity and no investors filing 526 petitions, you'd get a notice of intent to terminate. I recently have seen one 2 years after the latest exemplar approval. So I don't know if the 3 years is holding up. But previously, the first time you got one, you could show that you've been making efforts to recruit projects or recruit investors. And, you've been out there marketing, you've been doing due diligence on projects, but you haven't found a project that's actually worked, or you have a project, there's been non-EB5 investment in it, and you have been promoting economic growth. That used to be able to be enough to get you past the first NOID.
Yeah.
I'm not sure if it is going to be any further. I've recently seen a termination that I believe it was the first NOID. We did all that, and they still terminated.
Yeah.
Which is crazy because it takes them I know their processing time now currently says 14 months to 31 months, but my experience is that 14 months is a pipe dream. It's usually at least 2 years. It used to be 2 to 3 years or more to get a 924 regional center application or amendment approved. So they can take 3 years, but if you don't file an investment with 3 years, and you don't have an investor file within 3 years, they're going to terminate you. And Mona, let's be honest, to create a regional center and an offering package of documents and go out and market it, you're talking $100,000, $200,000.
Not only that, it takes a lot of time, especially recently. Once you lost the Chinese market, the rest of the world took a lot longer to convert.
Yeah, raising money, it just became much harder.
Yeah, much harder, much longer. Yeah. But on top of that, that's raising money. Actually, the project themselves so many things can go wrong. If you take a construction project, for example, you could lose. We have projects where the zoning the government changed, the zoning changed halfway through. So everything had to be redone. And then because they had to change their location, or there could be some other issue that, naturally stops it. There isn't an understanding with USCIS about business realities. And that's what I have been arguing time and time again.
No.
And I feel that comes out a lot in these NOIDs.
Absolutely. Especially like if you're dealing with California or New York City, permit delays are just the way things go, right?
Yeah.
It's not unusual in California to have a 2 or 3 year permit delay because the city wants you to do something, jump through more hoops. It's just the way it is, but you still get, maybe not not even just in the regional center context, the investors will get RFEs or NOIDs based on, we Googled your project and it's been 3 years and there's no activity. Well, we're going through the permit process. That's perfectly normal. There's nothing wrong with the project, but USCIS has actually started saying, well, that's a material change. So far I've been able to successfully argue against it, but they seem to be getting more and more intense.
So far, Dan, I hear you have been fighting with USCIS in courts a lot.
When all else fails, sue them. It's been working pretty well. It's not just EB-5. I've done it in L1s, H-1Bs, EB-1A. I've been suing them on a number of stuff. And mandamus, of course. We're doing mandamus like crazy because they keep delaying adjudications. Yes. So we actually sue them to get them to adjudicate.
Those petitions are individual petitions. They don't have huge repercussions. The difference is that if they start messing up with projects, most of the time the projects have some other link, and you're talking about huge possible failures. And the money issues alone, we're not talking about 1 million or 2 million. It's usually a lot of money involved. Plus the fact that everybody's petition who's within that project goes up in the air.
Oh, yeah. We will typically. But you have to remember that with USCIS, only the investor is party to his or her 526 petition. So the investor has to be a plaintiff. Often the regional center will be a plaintiff too, or the project, or they'll at least fund the litigation. But the individuals have to be plaintiffs or they don't have standing to attack the USCIS decision in a 526. But right. Yeah, USCIS has no concept that if you take a $20 million slug out of the capital stack that now has to be repaid because investors are denied, you may have banks foreclosing on loans. You may have people going bankrupt. You literally are going to start this flurry of lawsuits.
It's all a daisy chain.
Yeah.
Mm-hmm.
These are, 20, 50, $100 million projects. They're not, you can't just pull the rug out from under them without repercussions.
Exactly. And I feel like this is something that USCIS really needs to understand, because we are not in a normal circumstance right now. We're going through a depression a recession, I should say, because of COVID. We're trying to have a quick recovery, and we are trying to use EB-5 to help us with this recovery. And the last thing we need is USCIS to come in and start denying on issues where they shouldn't be denying in the first place. Saying which, the redeployment issues, which all came out last week, Dan. Retroactivity. How on earth can the USCIS in their right mind give us guidelines 3 years late and then say they're retroactive?
3 years. It's more like 5. We started first designing redeployment into our deals around 2012 because we started to see the backlog increasing, and we started to realize that a 5-year loan term wasn't going to be enough.
Yeah, that is early.
So certainly by 2015 or so, we were asking the question of USCIS. And actually, there's a stakeholder meeting where I personally asked Sarah Kendall, okay, we asked them about the redeployment policy. We asked if regional, the redeployment had to be in the same regional center. And the chief economist first said yes. And then the lawyers said something and said, no, I'm sorry, we haven't decided that yet. And then I asked Sarah Kendall, I said, look, okay, I understand that you don't know what your redeployment policy is today, but can you agree that you will apply it prospectively when it comes out so you don't hurt all the people that have redeployed in the meantime? And, she said, we'll take that into consideration. Well, yeah, they took it into consideration and then just didn't care.
I remember that, Dan. Yeah, my God, was that 5 years ago?
No,
how time flies.
Was 2 or 3. I think that was probably 2018.
2017. Yeah.
2 years, 3 years, 5 years, 5 days. At what point does this retroactive seem fair? And I think we're certainly beyond the fairness and the implication of that. It's going to be tough.
It is, because what's happened, Mark, is that a number of regional centers have already deployed their money outside of the guidelines. So now USCIS are saying that the rules are retroactive, and what's going to happen to those investors? Are they going to be deemed that their investment is not at risk? I don't even know what they would come up with, how you would challenge it. What are your thoughts, Dan?
Oh, well, I'll tell you how we're going to challenge it. We're going to challenge it through a declaratory judgment or an injunction.
See, I knew you'd know how to challenge it.
Yeah, we're going to Well, so one, I think there are a group of regional centers getting together, and they may bring a lawsuit prospectively.
Right.
Certainly the first time an investor is denied on this basis, there will be a lawsuit. The problem, it's a little bit complicated because if your 829 is denied, you get to renew that in removal proceedings. And there's a little bit of an issue about whether or not there's jurisdiction in the district courts if you can renew in removal proceedings. So, the worst case scenario is they have to actually take several years, go through removal proceedings, appeal to the Board of Immigration Appeals, and then appeal to the courts of appeals. And, by that time, we're 5 or 6 years later. So we're actually, that's why I'm hoping we can get together a group that's going to file prospectively a lawsuit saying this can't happen. There's also a comment period, which I actually, it seems like USCIS is actually trying to hide these things, because it took me about 20 minutes on their website to dig up the Q&A related to the new redeployment policy. And somebody else actually sent me the part of their webpage that says that there's a comment period until August 24th where you can submit comments on this regulation. So everybody in this business has to send comments.
Yeah, I didn't even know that there was that we could do a comment by August 24th. So we should get this out.
Yes. Well, I mean, yeah, like I said, it seems almost as if they're trying to make it hard to find so nobody comments.
Yeah.
But yeah, it's imperative that everybody who's affected send comments and saying, the rule of law and general principles of fairness dictate that if we asked you for years and years and years what to do and you didn't know, and we did something, and you did later decide that doesn't count, you can't hold it against us because it's your fault for not issuing a policy.
Yeah, that's just basic fairness. You're right. I don't think some of the other provisions are so bad. I think some of the provisions are very good, that you are able to have change your operating documents without it being a material change. Well, we're presuming no material change. There is a discretion that they have written in for themselves, which is also, I think, a good thing. The rules are not so hard and fast. But Dan, you, like me, wrote back in 2017 against redeployment even being necessary, because we're of the opinion that your money's at risk and you've created the jobs, and that's it. You don't need to keep putting your money at risk over and over and over again at such a stage that investors might lose their money.
Yeah, I don't know if I know Ron Klasko advocated that position pretty heavily. I think I was a little less clear on because the regulations do make it seem like the money has to be invested at risk throughout the conditional residence period, but that's only 2 years.
Right.
So the problem here that we have, and this is a really interesting contradiction, their policy allows you to put money in escrow until you get a conditional green card. But once you've deployed the money, that we all realize that that's just not feasible, because they also won't approve your project if your investment's 5 years. If the project is 5 years in the future, they're going to call it too speculative and they're not going to approve you.
Yeah.
And they'll only allow you to get a temporary bridge loan, which at one point they said was a year, and they backed off that, but it's certainly not 5 or 10 years.
And then the cost of a temporary bridge loan is not taken into account. So,
right.
I mean, it's just not feasible. It's not realistic. And nobody puts the money in escrow the whole way anymore.
No. But the thing is, the contradiction in the policy there is, okay, they're saying you've put the money into the project. It's created the jobs. It's done everything it should. It comes back. You still don't have your green card. You have to redeploy. But wait a minute. Your policy also says that I can put that money in escrow until I get a green card. Why should I have to redeploy in the interim?
Yeah, there is a contradiction. And my argument always has been is that there's no real oversight in the redeployment. Well, I suppose now the guidance is giving them some oversight. It is there, but it's still, as far as I'm concerned, it's not enough.
Well, I mean, there are some criteria now that, I mean, it's great to have more information than we did.
Yeah, for sure.
There's still some gaps in the guidance, but, it's better than we had.
Dan, if you could get a message out, or if you could speak directly to the folks on the Hill, what would you tell them?
Well, about the redeployment guidance, well, one, if we even need redeployment, but there is no path for investors in troubled projects. So people who have been either the victims of fraud or misrepresentation or misappropriation of their money, who have done everything they can, followed all the rules, put their money in, and just through no fault of their own have ended up in a situation where they can't redeploy through the same NCE because the NCE no longer exists, or they can't redeploy through the same regional center because USCIS terminated the regional center. There has to be an alternative other than deporting these people and their families who have done everything by the book.
Yeah.
The law and the policy really need to provide some kind of flexibility in some way that if these people, for instance, I have clients that they were in a project, somebody took some of the money, they've actually invested more money to make up for the money that was stolen and completed the project or are about to complete the project to create the jobs. Like they're going to fulfill all the requirements, but USCIS denies them anyway, even though they've taken an extraordinary step of investing more money, to make up for the loss. There needs to be a way for these people to get their green cards when whatever has happened is no fault of their own and they've been taken advantage of, they're victims. It's just not right to kick them out of the country for stuff that they had no control.
Yeah, Dan, I totally agree with you. Thankfully, we're talking about a very small percentage. I would like to end by saying that, yes, we do deal with the issues and the problems, but the vast majority of cases do get through fairly easily without any of these type of troubles.
Right. Yeah. And that being said, let's hope that all investors, whether they're in the majority or maybe this small impacted minority, hopefully there is a path for these investors that may find themselves in troubled projects due to no fault of their own, as Dan said. Well, Daniel B. Lundy, thank you so much for joining us on EB5 Investment Voice.
Sure. Happy to be here.
Thank you for being with us today on EB5 Investment Voice. The topics presented in this podcast is informational in nature and is not to be taken as specific legal advice. If you have questions on the topics presented in this episode or other investment immigration needs, please contact Mona Shaw & Associates. Mona and her attorney staff can be reached at mshawlaw.com. That's mshawlaw.com. Make sure you don't miss our next episode focusing on a different aspect of the EB5 program by subscribing to the podcast. While you're at it, leave us a rating on iTunes. If you really found this episode valuable, share it with someone else that could benefit from this information. Until then, I'll see you on the next episode of EB5 Investment Voice.